In this video I want to take a look at a question that I am very frequently asked. That is the question of the enforceability of a non-compete clause or a restrictive covenant in a contract of employment. My name is Terry Gorry. I'm a solicitor in Enfield in County Meath. I make videos about Irish law, business, entrepreneurship, that type of thing. Employees often come to me, they are either going to leave their job, they have a new job offer, perhaps a better position, a better job than they currently enjoy, or they've already left their job and they're concerned about the previous contract of employment. The previous contract of employment may contain what's known as a restrictive covenant. The restrictive covenant is also commonly known as a non-compete clause. Basically, it would run along the lines of you will agree on the termination of your employment, not to work in this industry or compete with this company for a period of perhaps 6 months from the date of termination within the area of Dublin or within 5 miles of your existing employer or whatever. Employees come to me then and they say, is this enforceable? What about my right to earn a living and so on? Bottom line is that the restrictive covenant or non-compete clause, as employees might refer to it as, is enforceable. There's no difficulty enforcing it generally, provided that the terms in it, the restrictions in it, are reasonable. Generally, a restriction for a period of 6 months from termination is seen as reasonable, and the geographical area then, that has to be reasonable as well, but I've seen restrictive covenants applying for the whole island of Ireland. In this particular case that I've just read about there in the Irish Times this morning online, it's obviously probably in the other papers as well, it involves a swim instructor working with, excuse me, or who did work with a company in Limerick who give swimming instructions called Swim Max Limited. The employee in question, Mr. Rojas, I think, left the job and according to the company began giving lessons within the 5 mile radius. Swim Max Limited went to the High Court and sought an injunction to prevent Mr. Rojas from giving lessons, and the High Court has granted the injunction on foot of the application by Swim Max Limited. Basically, a restrictive covenant in his contract of employment prevented him from giving swimming lessons within a 5 mile radius of his former employer's premises until mid-October. Mr. Rojas has agreed to do that, and the injunction also prevents Mr. Rojas from utilising any of the company's trade secrets and confidential information in relation to training techniques or carrying on in competition with SwimMax for 6 months after he departed the firm. This is a pretty straightforward situation. A lot of employers will not go ahead and try to enforce restrictive covenants, will not bother going to the High Court seeking an injunction, but some will. Swim Max Limited has done so. The question of costs then has to be decided in the future. Generally, the winner takes all. However, the judge said that the sides should adopt a practical position regarding any cost application. Mr. Rojas, I think, who defended himself, gave evidence that he wouldn't be in the best of financial health, whatever, and I think he mentioned obviously that he needed to earn a living and so on. So perhaps making a cost order against Mr. Rojas won't happen because the judge recognises perhaps the reality, and that's what the judge is hinting at there. But an employee is at risk of the cost situation as well, is at risk of a cost order being made against him or her, simply because it is a case of winner takes all, costs follow the event, and in this case the company SwimMax Limited have been successful in being awarded their injunction and have been successful in having the restrictive covenant in their contract of employment upheld and enforced. So again, it's a timely reminder, these restrictive covenants are enforceable provided that they're reasonable, and 6 months after you leave a job or are terminated or you decide to go someplace else, 6 months is generally seen to be acceptable and enforceable. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel.